Greetings. Welcome to the first lecture in Sealaska Heritage series celebrating Native American Heritage Month. My name is Chuck Smythe, and I'm the director of the History and Culture Department here at Sealaska Heritage Institute. SHI has started construction of its arts campus in downtown Juneau, which will expand opportunities for education and art. If you are interested in making a donation to the arts campus or submitting a letter of support to the Juneau Assembly for city funding, please visit sealaskaheritage.org/campus. The title of today's lecture is ANCSA Corporations and the Alaska Federally Recognized Tribe and their respective constitutional relationship with Congress. It will be presented by Chris McNeil. Chris E. McNeil Jr. is from the Eagle Ducklowaidee Pillaware clan in Klukwan, and his Tlingit name is Shaka Kuni. Mr. McNeil earned a law degree from Stanford University, a master's in political science from Yale University, and a BA in political science from Stanford University. He served as the president and CEO of Sealaska Corporation from 2001 until 2014. Originally from Juneau, Mr. McNeil served Sealaska in varying officer capacities from 1978 through 1993, and as a member of the board of directors from 1998 through 2000. Other positions Mr. McNeil has held include special counsel to the Alaska Federation of Natives, chairman of the Native American Rights Fund, the first director of American Indian Program at Stanford University, second vice president of the Tlingit and Haida Indians of Alaska, a director of Gold Belt Incorporated, director of the American Indian National Bank, president of the Juneau Tlingit and Haida Community Council, chairman of Tlingit and Haida Regional Housing Authority, Washington representative and counsel to the Mashantucket Pequot Tribal Nation of Connecticut, and chairman of the Native American Contractors Association. He is the owner of Native Strategy Group, which provides advisory services to Native organizations. Mr. McNeil.
Well, thank you very much, Chuck. I really appreciate the opportunity to be here to make this presentation, ANCSA Corporations and the Alaska Federally Recognized Tribes and their respective constitutional relationship with the Congress. The COVID-19 pandemic is still a national healthcare crisis. The total number of cases now exceeds 10 million in the United States. No one's immune. There's been no effective vaccine yet, and there's no effective therapeutics for those who get very sick. The Alaska Native community is being hit, and Native Americans are infected at rates at least 3.5 that of white people, according to the CDC. In especially hard-hit Native American populations, such as in New Mexico, the death rate has exceeded 17 times that of white people. Native Americans are 11% of the New Mexico population, but account for 57% of the infections. This is 19 times higher than all of the other New Mexico residents. Congress recognized the disproportionate impact on Alaska Natives and Native Americans. It enacted the CARES Act to help remedy COVID-19 and its healthcare and its economic impacts. They specifically allocated $8 billion to Indian tribes as part of this landmark congressional legislation. The allocation of the funds to the tribal governments immediately caused a conflict with certain federally recognized tribes and ANCSA corporations. The CARES language included ANCSA corporations with a definition of an Indian tribe under the 1975 Indian Self-Determination and Educational Assistance Act. The lawsuit was brought by the Chehalis tribe as lead plaintiff and included several other tribes around the country, including several Alaska IRA councils, and the Native American Rights Fund. The case is captioned Chehalis v. Mnuchin. The federal district court held that ANCSA corporations were included in the CARES Act because they are eligible as an Indian tribe. The case was appealed, and the federal appellate court in Washington, D.C. held that ANCSA corporations were not qualified for CARES funding. The Alaska Native Regional Corporations and Village Corporations have petitioned the U.S. Supreme Court to review this negative appellate court decision. If the petition is granted, it will be heard sometime in 2021. The case has pitted Indians against each other. On the face of it, it looks like a fight over money. The federally recognized tribes would like a major portion of the money. Should they prevail at the U.S. Supreme Court, the impact would be to allocate a disproportionate share of the CARES funding to the lower 48 tribes. Alaska Natives could lose out in the middle of a 100-year pandemic. However, there's more at play here than a contest over $8 billion. The case has revealed a debate about the parallel existence of the Alaska Native Claims Settlement Act of 1971 and the congressional amendments that included Alaska Natives in the Indian Reorganization Act of 1934. These amendments are called the Composite Indian Reorganization Act of 1936. The Chehalis tribes have argued that because they are not federally recognized by Congress as sovereign entities, they cite further evidence of this in that the ANCSA corporations are not included in the 1994 Tribal List Act. This has multiple implications for all Alaska Natives that are well beyond whether ANCSA corporations share in the CARES Act. They include the Chehalis could upset the role of ANCSA corporations that has been in place for almost 50 years. It would terminate a major part of Alaska Native rights under the Indian Self-Determination and Educational Assistance Act. And make no mistake about this, this is not Congress terminating Native rights, but this is by the hand of other Indian tribes. ANCSA corporations have relied on the Self-Determination Act for 45 years. The Alaska Native corporations rely on identical inclusion as an Indian tribe in over 60 other Indian laws of general applicability. In other words, other parties may seek to exclude ANCSA corporations from these programs. These Indian laws provide inclusion in the advancement of our subsistence, of our cultures, of housing, forest management, and federal contracting, to name a few. The other tribes are attempting to rewrite Alaska Native history. It attempts to nullify part of ANCSA as an Alaska Native and congressional solution that is unique to Alaska. There's an old adage that applies here. The victor writes the history of the vanquished. It's clearly something that we can't allow. This analysis will not focus exclusively on the legal arguments made by the Chehalis tribes, the Department of the Treasury, and the ANCSA and regional and village corporations. The Chehalis case itself is principally about the legal rules under which a court interprets federal law. The general principle is that a law is interpreted only in the actual language of the law, and it's only if the law is deemed to be ambiguous, that there is a reference to the statutory history for guidance or the statements that were made by Congress at the time to describe the law's intent. The CARES allocated $8 billion to tribal governments. It defined a tribal government by reference to a definition of Indian tribes in the Indian Self-Determination Act. On the screen, you'll see that the Section 5 of the CARES Act is as follows. An Indian tribe, the term Indian tribe has the meaning given to that term in Section 4E of the Indian Self-Determination and Educational Assistance Act. It states further that tribal government, the term tribal government means a recognized governing body of an Indian tribe. And then what you see next is the definition of an Indian tribe under the Self-Determination Act. And you can see that ANCSA corporations are specifically included in the Indian tribal definition. The Chehalis tribal plaintiffs have argued that even though ANCSA corporations are expressly included, that they're still not an Indian tribe, that they don't qualify because the ANCSA corporations don't meet the terms of what they have called the eligibility clause, and which is recognized as eligible for the special programs and services provided by the United States to Indians because of their status as Indians. The Chehalis tribal plaintiffs further argued that ANCSA corporations do not qualify as a tribal government because they are not a federally recognized by Congress. The CARES Act does not specify federally recognized, but they argue that federally recognized is an established meaning under federal Indian law. The ANCSA corporations and the Secretary of Treasury are petitioning for certiorari in the United States Supreme Court to hear these legal arguments. But let's discuss how ANCSA fits into the broader firmament of federal Indian law. In order to understand this, it's helpful to compare the relationship of the Indian treaties to the Congress, the IRAs to the Congress, and ANCSA corporations to the Congress. Because Congress has a direct relationship with Indian tribes through both treaties and congressional acts, we should first examine the relationship between US treaties and US laws. Up to 1871, the president, and with the advice and consent of the Senate, entered into many treaties with Indian tribes. A treaty is not itself a legislative act, but under the US Constitution is the supreme law of the land. Similarly, laws enacted by the Congress and signed by the president are equally the supreme law of the land. You can see this in Article 6 of the Constitution, and it provides this definition, which states both. Therefore, there is an equivalence between treaties and congressional acts under our Constitution. What is critical to our discussion is that there is a constitutional equivalence between Indian treaties and the Alaska Native Claims Settlement Act, which is a federal law. They are equally the supreme law of the land. We must also look to the Constitution to find Congress authority over Indian tribes. This is stated in Article 1, Section 8, Clause 3 of the US Constitution, and it states in pertinent part on the next slide. All legislative powers herein granted shall be vested in the Congress of the United States. Congress shall have the power to regulate commerce with foreign nations and among the several states and with Indian tribes. The first question is, who's an Indian tribe? And the answer there is deceptively simple. It is Congress that recognizes who is an Indian tribe through its laws. And up to 1871, the president and the Senate, negotiated Indian treaties with this advice and consent, and thereby also recognized Indian tribes. In the federally recognized Tribal List Act of 1994, the congressional findings state how Indian tribes are recognized in the present day. It states three methods, and the first method is by act of Congress. The second is in the Code of Federal Regulations, establishing Indian groups exist as an Indian tribe, and also by decisions of the United States Court. Even as Congress has delegated to the Secretary of Interior a non-exclusive regulatory responsibility to recognize Indian tribes, it clearly stated that Congress retains its power to directly recognize an Indian tribe. In other words, being recognized on the Tribal List Act is not the only path to congressional recognition as an Indian tribe. There is clear evidence of this congressional authority in the Clinton-Haida Status Clarification Act. It was enacted as a section of the same bill as the Tribal List Act in 1994. Congress has the plenary authority to set the terms and conditions of tribal recognition. We need look no further than the Clinton-Haida clarification of its tribal status to see how Congress can set terms and conditions of recognition. They include the following. Clinton-Haida cannot diminish the authority of the existing IRA tribes in the region. Clinton-Haida Constitution is not codified into federal law as a consequence of their recognition. And Clinton-Haida cannot overlap service contracts and grants with the IRA councils and essentially allow the region to double dip for services. What is important about this is that even if the Secretary failed to include Clinton-Haida in the Tribal List Act, Congress has preemptively reconfirmed its recognition of TNH as a federally recognized tribe. Therefore, it's legally unnecessary for the Secretary to include TNH on the list. It's an accepted case law that the nature of the relationship between Congress and Indian tribes is a political relationship and not a racial classification. And the lead case remains the case of Morton v. Menkari. If an entity is not recognized by the Congress as an Indian tribe in the law, then the law would be subject to a challenge of unconstitutionality under the Equal Protection Clause. This can be resolved in new laws if there is a congressional finding that an entity is recognized as an Indian tribe. Then the recognized tribe will be qualified for federal legislation that's intended to benefit Indians. The treaties, pueblos, Indian Reorganization Act councils, and tribes have been formally recognized by Congress, federal courts, and through administrative recognition processes described in the Tribal List Act, and they're considered Indian tribes under the Constitution. They have a political relationship and have inherent rights of tribal self-government. The IRA Council have rights of self-government as described by the IRA Act. The central question concerning the ANCSA village and regional corporations is whether they are recognized as Indian tribes under the Constitution and federal law. Sealaska's case is a statutory construction case. It's a contest of whether or not the corporations are recognized as an Indian tribe under a combination of three federal statutes: the CARES Act, this Self-Determination Act of 1975, and ANCSA of 1971. What the Sealaska case doesn't directly consider is whether ANCSA corporations are an Indian tribe under the Constitution itself. The answer is clear. Congress has multiple political relationships with Alaska Natives, its tribes, and its village and regional corporations that predate the IRA amendments of 1936 and ANCSA in 1971, and they also post-date both. The Congress has a political relationship with Alaska Natives as Indian tribes before the 1936 Act. The Alaska IRA amendments of 1936 set the terms and conditions of organization and governance of Alaska Native tribes who are so organized. The same can be said of the special Clinton-Haida Recognition Amendment in 1994. The ANCSA Corporation poses a different analysis. Some have suggested that ANCSA is a treaty substitute. I've suggested that it's a statutory Indian treaty, but in fact, it's neither. ANCSA stands alone and doesn't need to be forced into existing models of federal Indian law. Substantially, it shares some attributes of an Indian treaty, but it's not a treaty. A treaty does many things, including it's a bilateral relationship with the United States, even though many of them were signed under physical duress and there was a result of war. Indian chiefs or other leadership actually did sign these treaties. Among other attributes, it defined the Indian lands that were ceded to the United States, the Indian lands that were kept by the tribes, and any reserved rights that the Indian tribe had to the ceded lands, the scope of remaining tribal rights, and the remaining obligations of the United States to the Indian tribes. Who was an Indian tribe was not so much a necessity in the young United States. It was more what was needed by the United States than the Indian tribes. It was the United States that needed a definition of an Indian nation. Among other things, the United States was trying to avoid tribal alliances with the British. The United States needed an Indian governing body to negotiate and to legitimize the cessions of Indian lands to the United States. Even though ANCSA and treaty tribes share some common characteristics, ANCSA does not have to be a treaty tribe or even a federally recognized tribe to stand on equal ground with the other Indian tribes in its relationship with Congress. In order for the United States to settle the Alaska Native Aboriginal land claims, it had to have recognized Alaska Natives as constituting Indian tribes under the Constitution. There's no other possibility. Otherwise, ANCSA would likely have been challenged as unconstitutional under the Equal Protection Clause as a congressional act that allocated valuable US property to a racial group for no compensation. In fact, ANCSA specifically states, no village, native village means any tribe, land, clan, group, village, community, or association of Alaska listed under section 1610, 1615 of ANCSA. Well, the congressional findings in ANCSA did not expressly declare that it was a settlement between the United States and Alaska Native tribes. The tribal entities listed in ANCSA were in fact Indian tribes with sufficient authority to act on behalf of its members. Others might argue that ANCSA was a settlement with Indian tribes, but ANCSA terminated the political relationship with Alaska Natives on its own terms. The case law requires that Congress expressly end its relationship with an Indian tribe in order to be terminated. It can't be inferred. There is nothing in ANCSA that uses such terminology. In fact, in the mid-1950s, Congress was busy terminating tribes, and they really knew how to do this. You might say they're even quite expert at this, but they did not do this in ANCSA. Similarly, Congress left the IRA councils intact after ANCSA. There were two actions within ANCSA and that limited tribal rights. The first was in ANCSA itself that stated any Aboriginal hunting and fishing rights that may exist are hereby extinguished. The second was the withdrawal of the Secretary's right under the Alaska IRA amendments to establish Indian reservations in Alaska, and this occurred in Flitma in 1976. Neither congressional action was a termination of the tribal relationship, but it was a specific limitation of Alaska Native rights. Finally, the Tribal List Act is explicit that Indian tribes shall not be terminated except by act of Congress. The Chehalis litigants have made much of the fact that Congress authorized the establishment of ANCSA corporations under the corporate laws of the state of Alaska. This is true. They argue that ANCSA corporations are simply private for-profit corporations to be governed under the Alaska Corporate Code, and they just happen to be owned by Alaska Natives. And therefore, ANCSA corporations couldn't possibly be an Indian tribe because of its unique form of corporate governance, even though that governance was mandated by Congress itself. There's another land settlement that is similar that postdates ANCSA, in which Congress established and limited Indian tribes' governance authority. It is the Maine Indian Land Claims Act of 1980. In this act, Congress delegated to the Maine state legislature the right and power to implement the Maine Land Claims Act, and it severely limited the Maine Indians' lands, power over Maine Indians' lands that were actually held in trust. Their status as an Indian tribe with Congress is preserved, but their tribal governance rights have been limited. In contrast, the Alaska Statehood Act forever disclaimed an interest in Alaska Native property rights. This has meant that it has clearly recognized that Congress has principal jurisdiction over Alaska Native property under the Statehood Act itself. So that is both federal and state law. Congress could amend and remove the governance of ANCSA corporations under Alaska law at any time. The state of Alaska has agreed to Congress that there is continuing jurisdiction over Alaska Natives. The Chehalis tribes have missed the concept that Congress has plenary authority to establish and vary the governance of Indians and its lands while still maintaining the political relationship with them under the Constitution. Under ANCSA, Congress has done exactly the opposite of terminating its political relationship with Alaska Natives. And it's done this by elaborating their governance authorities of ANCSA corporations through amendments. It is fundamental that Congress has maintained its Article 1, Section 8 jurisdiction over ANCSA through the many amendments over the last 49 years. These many amendments have incrementally changed the rights and responsibilities of Alaska Native ownership and the governance of ANCSA corporations and its property. In the original ANCSA, Congress also mandated a study of ANCSA, the status of ANCSA and its impacts. And this was to be submitted in 1985. This mandates a continuing legislative oversight of ANCSA on its own terms. One of these ANCSA amendments could have been challenged as unconstitutional without Congress having maintained its plenary power over ANCSA corporations as an Indian tribe. Finally, there is a congressional finding in ANCSA itself that stated that Congress had invoked its Article 1, Section 8 authority in enacting ANCSA and amending ANCSA. The Alaska Native Claims, it states that the Alaska Native Claims Settlement Act and this act are Indian legislation enacted by Congress pursuant to its plenary authority under the Constitution of the United States to regulate Indian affairs. The Chehalis tribes have argued that if ANCSA corporations are not listed on the Tribal List Act and do not have the full array of tribal governmental powers, that therefore they cannot be an Indian tribe. However, the ANCSA corporations maintain its political relationship with Congress as Indian tribes, even though they don't have the full array of tribal government powers as other tribes do. Both ANCSA and the Maine Indian Claims Settlement Act were innovations in federal Indian law, and they do depart from the classic model of Indian tribal land settlements, but each has an equal position with Congress and with the other Indian tribes. Now, there's an impact here on our history. The Chehalis tribes have characterized ANCSA corporations as an outlier, not as an Indian tribe, by emphasizing that ANCSA corporations are established under the laws of the state of Alaska. They have all but argued that ANCSA corporations really aren't Alaska Native at all, because they're outside the norm of the governance of other Indian tribes. However, both Congress and Alaska Natives chose this model. For years, there's been a narrative that ANCSA model was forced on Alaska Natives as if they had nothing to do with it. The actual history in the Native community is that our leaders fought for decades for a land settlement with the United States. Food sales bought the tickets for the leadership to go to Washington, D.C. The absence of oversight by the BIA in ANCSA is no accident. The Native leadership sought to fire the BIA from future involvement in its land settlement. And they did this. The Department of Interior had only two governance responsibilities under ANCSA. One was to establish an official Alaska Native role, and second was to approve the original articles of incorporation and bylaws. And both were temporary authorities. They don't exist anymore. In the 1960s, the very paternal powers of the BIA were closely associated with the reservation system. So it makes sense that there was a confluence of interest between the Alaska Native community and Congress not to transfer what became the ANCSA assets into trust and to establish a reservation system. It's easy to imagine that if Alaska Native leadership were still advocating for a settlement today, it would be different. But that's really another discussion. What the Alaska Native community did achieve in ANCSA was it gained an extra set of tools, and they've been used to very good effect over the decades. At the same time, the Alaska Native tribes are strong, and they continue to seek more tools to advance the well-being of tribal members, such as including greater jurisdiction under the Violence Against Women Act. So there's plenty of room for both. And Congress didn't reconcile or integrate ANCSA and the IRA councils. If that is to be done, it's up to the Alaska Native community to figure out a new model, new relationships. I'm reminded of a witness that was giving testimony in the ANCSA hearings. At the time, one of the settlement ideas was that Congress was going to create a single corporation, ANCSA corporation, that held all the land, all the assets in it. This witness was really dismayed that this Native corporation could be bigger than RCA. RCA at the time was more like IBM. And the interesting part of this story is that RCA now exists only as intellectual property and a brand name, but the ANCSA corporations have grown into some of the most successful business enterprises in the state of Alaska. Now, there are public policy issues that are important in this discussion. The Chehalis tribes have narrated a story about ANCSA corporations, which is simply and factually untrue. They have argued that ANCSA corporations, if the ANCSA corporations were to receive CARES funding, ANCSA corporations will double dip billions of dollars, and this will be unfair to the other tribes. This was their most inflammatory allegation. They based this on the idea that there would be multiple and overlapping applications from the same Alaska Natives. This is a classic example of form over substance. And it's misleading by the factual omissions, which I'll describe here. In a federally recognized tribe located in the contiguous United States, an Indian tribe can submit a single integrated application that includes all of its divisions, and each division is owned and controlled by one tribe. Only one CARES application is necessary per tribe and can include all of these operation and budgets and employee headcounts. Tribally owned entities are also expressly included in the CARES legislation. And many of these tribal owned entities are in fact Indian casinos, which are very large. So the chart explains, graphs this out, that one Indian tribe owns all three of these entities, and they can be included in a single application. Alaska Native CARES applications are different because Congress enacted legislation that applied uniquely to Alaska Natives, but the common thread is that each of them is legally linked to a statutory recognition as an Indian tribe in the Indian Self-Determination Act of 1975. The pertinent language is in 25 USC 5304. The CARES Act is applied to Alaska Natives. There can be Alaska Native entities, and each is functionally distinct. They are the ANCSA corporations, the IRA councils, and the Alaska Native Tribal Health Consortiums. And you can see this in the application, the graphic below. The functions of the three Alaska Native tribes are the same as an integrated single application of a lower 48 tribe. And so there isn't any overlap, and there's certainly no double dipping. The substance is actually the same. Finally, the Chehalis tribes have distorted the comparative economic size of the ANCSA corporations and their tribal enterprises. The tribes have accurately stated that the ANCSA regional corporations generate approximately $10 billion of gross revenue. These aren't profits. The 226 village corporations generate approximately $4 billion of gross revenues. This is a large amount of gross revenues combined. But based upon these gross revenues, the Chehalis tribes have argued that it's unfair for multi-billion-dollar gross revenue ANCSA corporations to receive CARES funding. And they argue that these ANCSA corporations don't have a social, economic, or cultural role in the Native community. But ANCSA has very specifically provided exactly the opposite. Their arguments are misleading by omission of the stupendous dimension economic disparity between the two. In the latest published DOI, Department of Interior Indian Gaming report suggests that at least $36 billion in gross revenues from the Indian tribes. Some reports have suggested total stateside gross revenues of over $40 billion of the tribes. And one tribe even had a newspaper puff piece that suggested their gross revenue from their tribe alone was over $12 billion. Well, that one tribe is almost as large as all of the Native corporations combined. It's unlikely that in these numbers, the gross revenues of these Indian tribes include any of the 8A contracting revenues, resource development, tourism revenues, and other business enterprises. The fact is that gross revenues of Indian tribes in the South 48 are likely larger than $40 billion. And this is in comparison to the ANCSA Corporation's $14 billion. A second element of this is that the available net profits is higher for the Indian casinos than the ANCSA corporations because the casinos earn an even greater percentage of net revenue. Much of the ANCSA revenue comes from federal contracting, and these are much lower profit margins. Hypothetically, if ANCSA corporations earned an average 7% return, it would mean that they cumulatively have about $1 billion of net profits over the course of the year. If the Indian casinos are earning 20% net profits on $40 billion gross revenue, the total would be about $8 billion of profits per year. In absolute terms, that would be 8 times that of the native corporations. The main issue is that the tribes have criticized ANCSA corporations because of gross revenue size. And at the same time, it's an incredible accomplishment that the tribes have been so successful in Indian gaming, but it's very misleading to members of Congress to misstate the facts of this important issue. Now, this issue is still in dispute. There are 2 paths on how to resolve this, on whether ANCSA corporations would be Indian tribes for the purposes of inclusion in the CARES Act funding, and it also has potential impact on over 60 other federal Indian laws of general applicability. The first path is to resolve it through the courts. As indicated before, the corporations, ANCSA corporations, and the United States have petitioned for certiorari before the United States Supreme Court with the support of the state of Alaska and AFN. This is likely to be resolved next year. There are many strengths and weaknesses to this approach. The timing is off, though, because the coronavirus impacts are now. The help necessary for the Native community is now, and the infection rates continue to increase. A Supreme Court decision is also likely to be black and white. A negotiated solution with the Chehalis tribes at this point is unlikely. The other approach is to craft a technical amendment to ANCSA itself, in which Congress declares that ANCSA corporations are an Indian tribe, notwithstanding any other federal laws. There may be an opportunity to resolve this in the context of a lame duck session of Congress before Christmas 2020. If not, this could still be taken up in the next Congress in January 2021. The ANCSA Corporation and the village corporations follow these 2 paths in parallel. And it goes without saying that it's one of the most important legislative priorities of the Alaska Native village and urban village and regional corporations, and it deserves the support of the Alaska Native community. Thank you very much.
Thank you, Mr. McNeil. We have the ability for viewers to ask questions via the chat function in YouTube. Please provide us with any questions you may have for Mr. McNeil. The first question we have is, what would the consequences be for Alaska Natives should the Supreme Court hear the Chehalis case and find that Alaska Native corporations are not tribes?
Well, it'd be extremely difficult because at that point, all of these 60 or more federal laws are tied together, and a federal agency would be required to respect the definition. And they would have to say in those cases where an ANCSA corporation or a tribal organization associated with an ANCSA corporation applied, they would not be eligible by the definition terms of those various acts. So this includes, it has much broader impact than, simply the CARES Act of this year.
Okay, another question we have is kind of a historical question. What happened between the early 70s when these provisions and the Indian Self-Determination Act was passed and ANCSA was passed and laws like the National Historic Preservation Act was passed that recognized native corporations as tribes. What happened between then and now? What has changed in the agency's approach to these issues?
Well, the agencies developed an understanding that the ANCSA corporations were Indian tribes for the purposes of these acts over that period. In fact, it's actually quite important that ANCSA itself recognized this issue. In one of the last findings in the original act, it stated that Alaska Natives would continue to be eligible for the EDA and other Indian programs after ANCSA was enacted. So there was a concern. It wasn't like, this was a technical issue. And the reason is because there was a point in some of the early testimony of ANCSA where some people had the bright idea that they would merely take the money from the settlement and then make it replace federal funding. So essentially it would be a pure terminationist action. And so that's the reason why the Congress wanted to assure that Alaska Natives would continue to participate in these programs. And the extension of that discussion is actually the Self-Determination Act of 1975. In fact, Tlingit and Haida itself was one of the earliest contractors prior to the Self-Determination Act, because I worked for Tlingit and Haida in 1971, and we implemented the Higher Education and Assistance Act for college students, and that occurred under existing authorities prior to the Self-Determination Act authority.
Thank you. We have another question. If any Alaska Native corporations are profit-making entities and are incorporated under state law, why do regional corporations have to share 70% of their profits from subsurface resource development and timber development?
The Section 7I agreement is unique. It's as unique as ANCSA itself, because there's, as far as I know, there's no similar sharing of revenues among other Indian tribes. I mean, the easy metaphor would be if the Indian tribes were required to share their Indian gaming revenue, with other Indian tribes in a state or in a region. But that was a declaration of Congress's desire to assure that have and have-nots would be not equalized, but at least there would be a revenue sharing, so that those that don't have subsurface revenues would be able to share in those revenues on a statewide basis.
Well, good. Thanks again. You may have covered this, but I'm going to ask this next question. What is the next step if the Supreme Court rejects the petition for consideration, and how likely would congressional action be to solve the dispute?
Well, that's literally the $64,000 question here, because if it rejects it, it means that the appellate court decision would have to be honored by the agencies during the pendency of any discussion before the Congress. But at that point, the appellate court would be the law. And so it would really create a much greater urgency among Alaska Native corporations to get a resolution of this.
Well, thank you again for this excellent lecture and answers to questions. This is a very important topic and a very helpful, useful discussion here. SHI invites viewers to return for our next lecture by Dr. Thomas Thornton, entitled Values tenure and organization, critical dimensions of sustainable development in Indigenous Southeast Alaska, which will be broadcast this Thursday at noon. We have a link in the video description below for a survey we hope you will take a moment to complete. This will help us to continue improving our lecture series and also allow our funders to measure the impact of the program. SHI has started construction of its arts campus in downtown Juneau, which will expand opportunities for education and art. If you are interested in making a donation to the arts campus or submitting a letter of support to the Juneau Assembly for city funding, please visit sealaska.org, sealaskaheritage.org/campus. Thank you again.
Did you see those other questions?
Oh, wait a minute. No,
I sent you other questions
you did where?
to your email.
We have a couple more questions coming in. Hold on. I get my email here. I don't have them. So I guess I will thank you very much, and we will have to continue this at another time.
Thank you. Good night, Chief.
Sure. Goodness, geez.